Hello friends, I am Dr. Lakhvinder Singh. I am giving presentation on Article 12 of the Indian Constitution. This is basically the concept of state, and the learning outcome of this module is that in this module we will try to understand the modern concept of state under Article 12 of the Indian Constitution. We will also try to understand that how this state, the concept of state, has been developed in the various countries like United States and the United Kingdom. As we all know that Constitution of India is sovereign law of the land, and it carries the basic rule of law, basic notions of the rule of law, limited government, and it provides the structure, procedures, parts, duties of the government institutions, and sets out fundamental rights, directive principles, and the duties of citizens. Now the whole constitutional scheme prohibits all of the three organs of the state, and legislature, executive, and the judiciary, and from acting against the spirit of the Constitution of India. Even the Constitution of India, it prohibits the state from interfering with the individual's fundamental rights. The state cannot act arbitrarily, irrationally or unfairly. The state cannot impose unreasonable restrictions on an individual's fundamental freedoms. And in the landmark judgment of the Honorable Supreme Court of India in Menka Gandhi versus Union of India, the Supreme Court said that in order to limit someone's right to life and personal liberty, the state has to adopt just, fair, and reasonable procedure. So the state is under an obligation to act fairly without ill will or malice in law or in fact. So there is a concept of limited government, that government cannot exceed their powers, they cannot overreach their powers. All such constitutional remedies, they are available against the state's action only, and in other words, the fundamental rights can be enforced against the state only. An individual cannot enforce his fundamental right against a private individual. So the limited enforcement of fundamental rights involves serious implications and asks what would happen if private entities or non-state actors, and which are performing the public duties, if they violate our fundamental rights. So there is a need to understand this concept in the various countries also, like in United States. The United States Constitution, it protects rights and liberties of the individuals against the governmental actions. But there is also one 13th Amendment to the United States Constitution, which prohibits slavery and could be enforced not only against the governmental action but also against the private actions. In India we have the same provision like of abolition of untouchability. This is a right which can be enforced against the individual also, private individual also. So except to the 13th Amendment in the United States Constitution, all other guarantees can be enforced only against the state action. State action is a conduct of any state or federal government. So 13th Amendment, the 14th Amendment, and the 15th Amendments were enacted in order to protect freed Negroes from all forms of oppression by the states. Now there is a famous case, United States versus Cruikshank. It's a case of 1876 in which basically the US Supreme Court, they recognized the state action doctrine in dictum and stated that the 14th Amendment, it prohibits a state action only and not that of the private citizen. So it was a serious issue. The court said that the provision says nothing about the rights of the one citizen against the another citizen. Later on, there was a case, civil rights cases, 1883. The United States Supreme Court, they struck down the Civil Rights Act of 1875 and held that the 14th Amendment, it prohibits a state action of a particular character only. The court said that the wrongful act of an individual is simply a private wrong, but this was a strict interpretation, so it was severely criticized, and because of its strict interpretation of state action doctrine, the racial discrimination remained a continuous and unending practice of the American society. However, the courts, they gradually expanded the definition of state action and brought many private actions within its ambit. During 1940s, the court severely criticized the arguments of the civil rights cases. There was a case, Smith versus Allwright, 1944. In this case, a state law authorized the political parties to frame their own rules for the primary elections. Now the political parties prohibited the non-white voters from participating in the primary elections. The court considered the exclusion of non-white voters as a state action and held that such action was in violation of 15th Amendment. Another case was the Shelly versus Kramer 1948. In this case, the legality and the enforceability of the private agreements barring the people of Negroes or Asian race from occupying the property in a real estate, they were challenged. The court held that the enforcement of the racially discriminatory restrictive covenants was a state action and therefore prohibited. Another case was of Burton versus Wellington Parking Authority 1961, in which a restaurant which was physically and financially under the control of public authority refused to serve food or drink to a person because he was Negro. Now the court held that it was a state action and discriminatory in nature. In the year of 1972, in the case of Moose Lodge versus Irvis, a racially restrictive private club refused to entertain the African American guest. The court held that it was purely a private citizen action. The court said that even if the authority had granted a liquor license to the private club, it did not make the private club's discriminatory action a state action under the 14th Amendment. So it was developed in that manner in the United States. Now how it developed in the United Kingdom, it has a different story. Now in the year of 1998, Human Rights Act was passed in the United Kingdom. This was passed to make the public authorities more accountable and to provide effective remedies in United Kingdom courts for breaches of human rights. Now section 6 of the act, it prohibits public authorities from acting in contravention of the fundamental rights and freedoms mentioned under the European Convention on Human Rights. Section 7 enabled the individuals to enforce such fundamental rights and freedoms in the courts of the United Kingdom. Now the purpose of the Human Rights Act of 1998 was passed in those times when the role of the private and the voluntary sectors in the provision of public services had been increased. Therefore it was enacted to cover those functions also which were performed on behalf of the state by private or voluntary sector bodies acting under either statute or under contract. Section 6 identified two distinct categories of public authorities which would have a duty to comply with the convention rights, that is pure public authorities such as government departments, local authorities or the police, and the functional or hybrid public authorities which performing the functions of public nature. Now the state cannot escape from its responsibility to protect one's human rights by delegating its essential public functions to private bodies or individuals. Moreover, the wider interpretation of public authority has also cast a positive duty on the state to protect people's fundamental rights by taking some active steps, and this should be done without any discrimination. In one of the judgment, Popular Housing versus Donoghue in 2001, a housing authority providing rented accommodation on behalf of a local authority was held a functional public authority. The court also gave some guiding factors for determining functional public authority, which are as follows. One is statutory authority, control by the state, and proximity of the relationship between the private body and the delegating public authority. In another case, Callan, Heather and Ward versus Leonard Cheshire 2002 judgment. In this case, the Court of Appeal held that state funded patients in a privately operated care home could not sue the private care home under the Human Rights Act, because the provision of care was not a public function under section 6(3)(b) of the Human Rights Act of 1998. However, in one of the case R versus Partnerships in Care Limited 2002, a private provider of mental health care was held to be a functional public authority within the meaning of section 6(3)(b) of the Human Rights Act. Now let us start with the concept of state under Article 12 of the Indian Constitution. Now Article 12 of the Indian Constitution, it defines state to include the government and the Parliament of India, the government and the legislature of each of the states, all local authorities and other authorities within the territory of India or under the control of the government of India. Now the most problematic expression under Article 12 is other authorities, as this expression has not been defined in the Constitution. So, it is for the courts to interpret this term, and it is clear that the wider this term is interpreted, the wider the ambit of the fundamental rights would be. In the year of 1954, the case is University of Madras versus Shantabai. Now, in this case, the Madras High Court evolved the principle of agisdum generis, which meant only authorities that perform governmental or sovereign functions can be included under Article 12. The court interpreted the definition of state in a very restricted sense. The court treated the definition as exhaustive one and confined to the authorities or those which are of like nature. In the year of 1967, there is a case Rajasthan Electricity Board versus Mohanlal. In this case, the Honorable Supreme Court of India held that the other authorities included those authorities which had been created by the Constitution or under any statute and on whom powers had been conferred upon by law. And it is immaterial that some of the powers conferred on the authority may be for the purpose of carrying on commercial activities while deciding the status of authority under Article 12 of the Indian Constitution. Now, in the year of 1975, there is a case Sukhdev versus Bhagat Ram, in which the court discussed the status of statutory corporations like ONGC, LIC, IFC. So, while deciding the scope and status of these corporations, the court held that all of these corporations were the state under Article 12 of the Indian Constitution, because these corporations were created by statutes, had the statutory power of to make binding rules and regulations, and were subject to pervasive government control. So, the concept of state was developing in this era. In the same judgment, it is Justice Matthews who gave a concurring judgment. Justice Matthew, in his concurring judgment, went further. He said that a state acts through the instrumentality or agency or of natural or juridical persons. It means that if an action has been done by a state's instrumentality or agency, then it would amount to state action. In order to find out whether an entity is a state's agency or instrumentality, he gave determining factors like whether the state has financial and administrative control over the management and policy of the agency, whether the entity or instrumentality or agency is performing an essential public functions, whether the entity or agency is carrying out business for the benefit of public or not. Justice Matthews' concurring opinion became a guiding factor for the future judges to determine whether an entity is a state's agency or instrumentality or not. In the year of 1979, R.D. Shetty versus International Airport Authority, the court laid down 5 tests to be considered other authority, which were: entire share capital is owned or managed by state, enjoys the monopoly status if the authority is a department of government is transferred to corporation, functional character governmental in a sense, deep and pervasive state control, object of authority. In the year of 1981, the Supreme Court again dealt with the same issue in the case of Ajay Hasia versus Khalid Mujib. In this case, a regional engineering college was under the government's financial and the administrative control of the government. The court held that the college was an authority for the purpose of Article 12. Now, the court laid down the following tests to determine whether a body is an instrumentality of the government or not, like if the entire capital of the corporation is held by government, where the financial assistance of the state is so much as to meet almost entire expenditure of the corporation, whether the corporation enjoys monopoly status which is state conferred or state protected, existence of deep and pervasive state control, if the functions of the corporation are of public importance, if a department of government is transferred to corporation. So, however, these tests are not conclusive, they are not exhaustive, these are inclusive in nature. In the year of 1987, in case of MC Mehta versus Shri Ram Fertilizers, with regard to private entities, the Supreme Court widened the meaning of state action. The court stressed that the ambit of Article 12 should be enlarged in order to bring private companies under the strict scrutiny of fundamental rights. In the year of 1993, very crucial issue was discussed in the case of JP Unnikrishnan versus State of Andhra Pradesh, that was of right to education. The court held that the private educational institutions, they cannot be allowed to violate Article 14, as they are performing a public function of imparting education. This kind of judicial interpretation of Article 12 is very essential in the impartation of free and compulsory education in India, because right to education is a fundamental rights, and even we have enacted the right of free and compulsory education Act 2009. So for that purpose we need the wider ambit of Article 12 of the Indian Constitution.